Hello. Thanks to a question that was asked here on the channel, we are talking today about the lawsuit steps. So, what to expect if you're going into a litigation, what are you facing, at least what are you facing in Quebec. There are several steps which are provided by the Code of Civil Procedure. There might be some derogation. I'll tell a little bit more about that later. But altogether, this is something like that. So when you probably tried and failed to get to some agreement about your civil rights, we're talking about civil litigation, by the way, then first thing by the code that you do, you're sending a letter of formal notice, the mise en demeure, explaining the gist of your claim, giving some context, some chronology of facts. You're writing to the other party, but in a sense to the lawyer of the other party that would be reading that. So you're explaining the legal story. And later on, very well might be that the same letter will be read by the judge in your case. So you're just explaining it all. You're making it not emotional, not just neighborly or involving your family relationship or any sort of relationship. You're just writing the fact. This happened, this happened, this happened, this happened. Therefore, you violated my rights or you did this and this wrong. And therefore, I demand this, this, and this, that you stop doing that, that you do that you pay this amount based on this evidence. And you give some time. We discussed the letter of formal notice in some other videos here on the channel. So you send it, and if there is no cooperation, if there is no further negotiation, mediation, arbitration, so if there is an impasse, legally speaking, then you apply to the court. You ask the judicial system, the court, the judge eventually, to definitively answer who's right, who's wrong, who owes whom, how much. So this is your application. You again repeating all the facts, you're citing all the evidence that you have, you're attaching copies by way of exhibits. You're submitting it to the court, paying your court fees, obtaining your court number, and based on that, you notify all the parties, all the interested parties. That's important because without such a notification, there will be no valid decision. If anybody is sued, according to the rules of procedural fairness, that person should know about that. So you notify. You notify not in any way, but in a specific way, usually via bailiff. And if that person is not in Quebec, sometimes not even in Canada, then you arrange for a bailiff in that other province, or maybe you're going by the procedure of the Hague Convention if the other country, the other jurisdiction is a party to this Hague Convention. So eventually you collect all the evidence, normally within 60 days from the moment when you got your court number, at least in Quebec. You provide proof of notification to your court file, and from that point, it's started. Then the parties have either 15 days if in Quebec or 30 days if outside of Quebec from the moment of notification to provide their answer. It's just one paragraph statement saying that we are going to contest. We disagree. If the other party did not provide that, then with the proof of notification, of course, that the party was duly informed, then it is supposed that the party is not interested or the party is by default in agreement with the judgment that will be rendered. So the party that way waives his or her right to provide their own representations, explanations, and claims before the authority, before the judge, before the court. So if there is no answer, then you might apply for a judgment by default. It does not necessarily mean that the judge will give you whatever you asked. The judge will still review your evidence. So it's important, even if you're not expecting any contestation, to provide all the good evidence. But at least the chances that you will give a judgment in your favor are high in such a situation. If there is an answer by the person directly or by the person's lawyer, and the lawyer should be one in Quebec if the whole procedure is in Quebec, even if the person, him or herself, is not in Quebec. Well, not the lawyer in Quebec, but the lawyer licensed to practice in Quebec. That's a little bit different. So, with that lawyer, yourself or your lawyer will establish a so-called case protocol. And for that, you have 45 days from, usually either from the moment that you contacted or from the moment that there was an answer, or if there is no other just starting point, then from the moment when it all started. Even the Court of Appeal agreed that there might be several starting points to calculate, so be attentive to that. But if you missed this deadline to provide the case protocol signed by both parties or by all the parties to the court, then the judge might impose his or her own case protocol, or the judge might summon the parties to hear them on the matter of case protocol and then again impose the case protocol. The case protocol is the document which cites what steps are expected in preparation for the trial and what are the deadlines. Basically, the idea of the case protocol is to prevent this litigation from lasting forever, as it often happened before. So, again, by default, you have 6 months to prepare. Often, because of some more or less objective reasons, like the expertise was not ready, the stenographer was not available for a pretrial examination, somebody was ill, COVID happened, there might be an application to extend this 6-month period for another 2, 3, 4, 5, 6 months. Sometimes even to stay the proceedings if there is a clear perspective of an agreement, if there are some active negotiations or something like that. But all in all, the case protocol sets like, okay, this interim application to dismiss or to clarify, for example, should be filed before this date. The cross application, if any, should be filed before this date. Expertise joint or by the parties should be filed before this date. The pretrial examinations, interrogations, depositions should be done before this date, and the document requested should be provided before this date, and so forth and so forth. So this is the gist of the case protocol. Later, if something does not go according to the case protocol and the parties cannot agree, they might apply for a case management, or if something goes beyond the case protocol, so that the judge would resolve the procedural issue, not the matter, not the merits of the case, but like who should do what and when and by what time. And same way, the judge might extend the deadline for the case protocol, or just confirm another second, third case protocol of the parties. So even with this idea of the case protocol, it's not guaranteed that everything will be finished in 6 months, unfortunately. And it's not unusual, though it may be unfortunate, that there is third, fourth, fifth extension, and the cases are being prepared for the trial for years and years, though every next extension is usually frowned upon more and more from the bench by the judge. Well, depending on particular facts, of course, because sometimes it's really necessary, but not always. Once finally all the steps by the case protocol is done, before the deadline set within the last case protocol, the plaintiff, the one who applied, should initiate and submit either jointly with the other party or at the very least, like unilaterally, the application to set down for trial and judgment. Basically, it's a paper telling the court, we are ready. Please give us a trial date. Then, depending on the courthouse, the procedure is more or less straightforward. Sometimes there is a specific hearing to deliver the date. Sometimes the court clerk simply contacts you, both parties, all the parties, presenting possible dates, and then you agree on some. Sometimes in certain courthouses, you might even have an idea who will be a judge. In the bigger courthouses, the Montreal courthouse, for example, you normally do not know who will be the judge at that point. But at least you would know your trial date. Again, unfortunately, but in many cases, at least in Montreal, the date is really far, within a year, something more than that, sometimes more than that. Of course, if the trial is a very short, like 1 day, 2 days, it's easier to find a closer date. But if it's 3, 4, 5 days, 7 days, then usually you're looking at the time period more than a year. Unofficially, the idea, at least as I understand it, is to give parties time yet to agree on something, like seeing all those delays. But on the other hand, the legal system is really overloaded. Then finally you have your trial. If there is no agreement before that, if there is no negotiation, if there is no settlement, because you can negotiate and get a settlement like all the way till the very last minute. And you'll simply inform the judge at the end, okay, we agreed. And that will be it. But if there is no agreement, there is a trial, so that the plaintiff, the one in attack, presents his or her position and the evidence, then the other party, and then if there are lawyers, the lawyers of the parties present legal arguments before the judge with respect to the facts as they were discussed. And then the judge rarely delivers a judgment on the spot. Mostly it takes several months again for a judge to write down and just deliver the judgment. And from that moment, you have 30 days to go for appeal. If you miss that deadline, it's not like a complete disaster. There are situations where you could still ask to relieve you from default, but again, normally the time for appeal is 30 days. And if the appeal is going on, which is not always advisable, most times it's not advisable, but sometimes it is. Then there will be yet another year or so, and again, there might be case management, and the documents should be provided, and the brief and everything. Well, if you go for appeal, most probably you have a lawyer, so your lawyer would know. And then after the judgment on appeal, like again, 99.99% of the cases, it's over. But sometimes some party wants to go to try their luck before the Supreme Court of Canada. For that, there are 60 more days after the judgment on appeal to go. So these are the steps, and this is, as you can see, quite a lengthy time frame. Not to mention that if you have a lawyer, or even if you don't, it's still costly. But with a lawyer, it's even more costly. So before you even start, it's a good idea to review what is there, like laying in front of you, what's the road, what's the path, and decide if it's worth it. Because most of the cases in like civil litigation, they're about money at the end of the day, and there's like cost effectiveness analysis. It's one of the advised exercises to do before you even start with the litigation. This is a good time to remind you that, but for litigation and, on the other spectrum, direct negotiation, there are two other mechanisms like mediation and arbitration. Both can bring you to either agreement or at least a decision significantly faster and in a less expensive manner than the full-scale litigation. But to go there, you'll need cooperation of the other party, because mediation and arbitration, in most cases, are voluntarily exercised. Like they need cooperation of both parties. They're voluntary. So this is it. I hope you would have some better understanding before you go there. Thank you. Have a nice day.